I think we're going to get started now with the final panel of the conference. In a conference on history, I suppose the future should be the last thing that we talk about at the very end. So I'd like to thank Michael and also thank Rebecca for doing such a great job with the conference. It's really been a wonderful experience. So after 2 days of talking about what judges do, we're now going to actually have a judge talk to us about what he does. And so the first panelist is going to be up on the screens, and it's Judge Andrew Oldham from the Fifth Circuit. So take it away.
Can you hear me okay?
Yes.
Can you hear me?
Yes.
Oh, great. Perfect. Well, thank you for having me. I'm very sorry that I cannot be there with you in person. And I'm also very sorry that I haven't been able to see the other panels, but I have read the papers and have learned a great deal. In my opening remarks, I'd like to make 3 brief points. The first 2 are based on an article that I wrote in the Harvard Law Review Forum last year in response to my dear friend Steve Sachs. We had a dialogue on today's topic, and the third is about an area of law that I'm particularly passionate about, but did not get its own panel at this year's conference, and that's administrative law. So before I get started, I will issue the obvious disclaimer that I am not an academic. I never have been, never will be, and so while I will try to tailor my comments to this setting and our audience, I'm obviously a fish way out of water here. And so when I say something about an academic paper or a theory, or when we get to the back and forth with my esteemed co-panelists, I hope you will forgive me for straying way out of my lane and to understand my perspective as someone who is more focused on practice than academic theory. So with that disclaimer out of the way, let me start very briefly with my friend Steve Sachs and an article that he published in the Harvard Law Review last year entitled Originalism, Standard, and Procedure. In that article, Professor Sachs argued that originalism should be assessed as a standard of correctness and not as a procedure for finding the correct answer. So in his words, originalism, quote, picks out a destination, not a route. Or put differently, originalism tells us whether the 14th Amendment protects X or Y, but it does not tell us necessarily, again according to Professor Sachs, how we go about determining the original meaning of the 14th Amendment, X or Y. And we've heard a lot today, and I've read a bunch of papers from the other panelists that offer commentaries, I think, in a similar vein. Does the Second Amendment protect X or Y gun right? Does the First Amendment protect this or that speech or prayer? And those are obviously hugely important questions, obviously important for everyone in the academy and outside of it to debate them. But the first proposition I'd like to throw onto the table is this. To the extent that we care what courts have to say about originalism, I think we would be well served to focus on the question that Professor Sachs tells us is not even an originalism question at all. Namely, how do we go about determining original public meaning? That is, how to operationalize the theory, what to read, what order to read it in, what weight to give a source, whether to discount this or that. Because those are the methodological questions that actually affect court cases. Those are where the rubber hits the road or where the academy enters the courtroom. And it's not clear to me how or where these methodological questions intersect some of the broader originalism debates that we've had over the last couple of days and more generally. So for example, we've heard about my friend Professor Bode has talked about constitutional liquidation. I learned about a new theory that I hadn't read about before this week from my friend Sharif Gerges called living traditionalism. We've all read and participated in debates about common good constitutionalism, and those are obviously very important debates. I don't mean to suggest they're not, and you could argue that they're the most important debates. But it's not clear to me what a judge is supposed to do with those, how are they operationalized in cases and controversies. I suppose one answer is that we shouldn't really care about the cases or the controversies until we get to the bottom of the broader theoretical debate. Perhaps put differently, one is to put the cart in front of the horse. But the cases keep coming. Courts have to decide them every day. And one of my principal worries about originalism is that the absence of a robust consensus on how to do it fuels so many criticisms of it. So, for example, we've heard about the siren song of objectivity, criticisms of judicial realism, et cetera. So my first observation is that those who care about originalism and defend it should focus on explaining how to operationalize it. My second point is perhaps the most obvious one, but as the non-academic here, I feel obligated to make it, and that is that there is an enormous gap between the academy and the bar. I read briefs on constitutional questions every day. I read Supreme Court briefs with some regularity too, although obviously less now than when I was a practicing attorney. And so much of it looks, like Jack Balkin says in the opening of his paper, like a law office history, whereas Justice Kagan has recently bemoaned it, judicial chambers history. Folks cite this or that case from the 18th century or this or that source from the Founders' Constitution, and they call that an originalist argument. This is particularly an acute problem in the inferior federal courts, where obviously the quality of representation in the briefing is not what it is at 1 First Street. But I think it's a problem everywhere. And from my perspective, 2 dimensions of this problem are particularly troubling. One, without a theory, a unifying theory of originalist procedure, what is our standard for criticizing this approach that is sort of cherry picking? I'm going to talk about the Countess of Rutland's case, or I'm going to talk about this Federalist paper instead of some other source or other sources. I'm sure it strikes you as wrong. It certainly strikes me as wrong. But why is it wrong? One answer is that Party A ignored this source or that source that you think is relevant. But if you, as the critic of Party A, ignored other sources, then what's your rejoinder? I mean, after all, you have to brief the case under time constraints, word limit constraints, and so you're not going to be able to cover everything. I suppose another answer is, well, we should just defer to someone who has a PhD in the particular historical question at issue. But what if there are 2 competing PhD historians? Who's to say which is correct? And without a theory for operationalizing originalism, who's to say that we should stop at 2 or 4 PhDs? The second dimension of this that really troubles me is that the debate is all done at a level of abstraction that is just incommensurate with judicial decision-making. We have to decide cases in a timely fashion. We don't have years to study each one. We can't phone a friend or invite a brief from our favorite PhD historian or a collection of them. So what is the hapless judge to do? Is it really a choice between judicial chambers history or law office history and just ignoring the history altogether? Because that doesn't seem like a particularly satisfying choice. My third and final sort of opening point is about, we were asked to sort of talk about the future, as Pam pointed out. And one of the things that strikes me as perhaps most interesting about the future of this debate is in administrative law. It's a topic that I think is a rich new frontier when we talk about these sorts of history and tradition kinds of debates. The Supreme Court recently granted a cert that some say will tee up Chevron for reconsideration. And such reconsideration, if it were to occur, would tee up all sorts of interesting originalism questions about the separation of powers. So I think that's an obvious place where the stakes for history, tradition, and originalism will be quite high. So thank you again for having me. I look forward to the discussion.
I'd like to break down what I want to say across something about courts and the future of courts relative to some of these text tradition and history concerns we've been talking about, and then separately about the academy and what we ought to be thinking as academics on these issues moving forward. So to start with the court, some of which my thoughts on this are, I think, more predictive and others are more normative. But I have real concerns in particular about this notion of relying on traditions in the way that the court has articulated over the last term in particular. And I have concerns on it both from a sort of guidance perspective about how it helps us try to understand the Constitution, and from an authority perspective about how it helps us correctly think about the Constitution. One of my concerns about this kind of reliance on tradition and appeal to tradition that some of the justices seem to find appealing at the moment is to repurpose a statement from Justice Scalia. That appealing to traditions often seems a lot like looking across a crowd and picking out your friends. And that seems not a very good way for the court to proceed when it's trying to think about what the Constitution means when it wants to exercise the power of judicial review. We need to have a better form for trying to cabin and constrain our efforts at traditions. Moreover, in thinking about sort of what role traditions ought to even have in understanding the kind of constitutional text we have, I worry very much that appealing to traditions will also overlook an important distinction between principle and practice, or as was referred to on an earlier panel, between what we preach and what we actually do in practice. And that what the Constitution is ultimately trying to appeal to, and the kind of rules that are embodied in the Constitution are trying to do ultimately, is appeal to a set of principles. And if we wind up substituting in a set of practices as to what legislatures and government officials are actually doing on the ground, if we substitute those practices for the principles the Constitution is attempting to embody, we're going to be going down the wrong path. We're going to miss part of what the Constitution is trying to accomplish. We wind up entrenching sets of practices and reinforcing sets of practices that, in fact, the constitutional rule ought to be disrupting and overturning. And so in general, I think the appeal to tradition is often misguided and can distract us from what we ought to be more focused on, is what we think about the meaning of the Constitution ultimately is. A second point about courts is the extent which builds on something about that we've just seen across the panels today, which is to what degree should we expect the court to be uniform in what kind of methodology it adopts in engaging in constitutional interpretation across a variety of doctrinal and substantive areas. In particular, for example, should we expect the court to make the same kinds of arguments in constitutional interpretation when it's focused on the free speech clause of the First Amendment as we would see in other provisions of the Constitution more generally? As was noted, the court doesn't talk very much about originalism. Our history, when it's talking about the free speech clause, it talks a lot more about it in other contexts. And fundamentally, I don't think that will change. I think the court will continue to treat these different provisions of the Constitution differently, in part because I think there's no particular pressure that drives the court to try to treat them all the same. One feature of originalist kinds of arguments and historical arguments in thinking about what the Constitution means is they're often very useful as critical devices to disrupt current understandings of what the Constitution is or current practices. It's a way of saying, you're thinking about this wrong, you're doing it wrong because it's not firmly rooted in these original meanings. That's how originalism arose in the first place, was precisely by criticizing the Warren Court and say they're going off on a trajectory that's not justifiable from a historical perspective, which means that though if you're very satisfied with what the current doctrine looks like in a particular area, as the court, for example, I think mostly is relative to the free speech provisions of the First Amendment, there's no particular incentive to try to disrupt that and overturn that and unsettle that by appealing to history and originalism in that context. You're perfectly satisfied to continue going along with existing doctrine until something forces you to have to think more carefully and more deeply about it. I don't think anything is very likely to force the court to want to think more carefully about the free speech provisions in particular. And then the third point about courts in particular in the future is I think the court needs to be thinking more about its role in the judicial hierarchy, which is to say the U.S. Supreme Court sits, of course, at the top of an appellate structure. Lower courts below it are ultimately responsive to what the U.S. Supreme Court does, which means an important aspect of what the Supreme Court ought to be doing is providing guidance and constraint to the lower courts. And I think that has two particular implications in this immediate context. One is it would probably be helpful if the court were to clarify the extent to which it expects the lower courts to be doing the same thing as a form of constitutional interpretation and opinion writing that the U.S. Supreme Court does itself. And I don't think there's any intrinsic reason why, in fact, we ought to think that circuit courts should be behaving the same way as the U.S. Supreme Court, which is to say, when the U.S. Supreme Court is trying to think about what's the fundamentals of constitutional interpretation when it comes to particular constitutional provisions, we might well expect the Supreme Court to go on deep dives in the history in order to try to uncover that. But I think the Supreme Court's job is ultimately to emerge out of that historical process and provide some clear guidance to the lower courts about what they ought to do going forward, which is to say, distill that into doctrine. And one of the crucial features of doctrine is, will it provide clear guidance to the lower courts so they don't have to go on their own deep dives into history, but can instead simply try to apply that doctrine going forward. But a second feature, I think, of that kind of process is the court will have to get to work more, which is to say it has to take more cases. You shouldn't expect a court that's going to actually be supervising the lower courts, especially in unfamiliar areas of doctrine, as we're moving forward with new doctrines. You shouldn't expect the court to be able to sit back and just say, well, the circuit court's going to handle most of this. We're going to deal with 60 cases a year, and we're good. Instead, you should really expect the U.S. Supreme Court to be intervening much more often, providing far more interpretation about how to think about these particular provisions. So if it's going to move forward on things like re-understanding the Second Amendment, instead of saying, well, we're going to issue one giant opinion, throw everything at the wall, and we'll come back to this several years from now, instead the court really ought to be thinking, we're going to be taking 2 or 3 Second Amendment cases for the foreseeable future until we get this clearer and more resolved, precisely in order to provide guidance and constraint on what the circuit courts are doing. And what the court ought to see itself as doing in part is intervening in the circuit courts and hitting them over the head when the court thinks they've gone wrong. So secondly, I'd like to turn briefly to some questions about the academy and the future of the academy with these kinds of debates. And here I want to build in part on what Judge Oldham just said, which is, I think, a crucial feature of where we are now relative to what the courts are doing and what academics who are interested in originalism should be doing, is it's necessary for academics, I think, to be thinking much more carefully about methods and applications of originalism in this point. To the extent that we have courts that are now prepared and interested in trying to apply originalist methods, try to be guided by originalism, more generally, it really is incumbent, I think, on academics to be taking the time to think more seriously about applied originalism and what that looks like in order to provide the resources the judges are going to need and the kinds of arguments that are going to be useful for litigants as well as judges going forward. I don't think that's all originalist scholars need to be doing, but I think it's certainly part of what originalist scholars are going to be doing. I think there are some open questions, though, and then interestingly, I think there's probably a question that's no longer so open. So about 10 years ago, I wrote a piece on what I characterized as a critical guide to originalist debates, and in that I highlighted several things I think originalists tended to agree on, and then some points of internal disagreement that still exists within originalist scholarship. And one of the points of disagreement that I thought still existed among original scholars was the question of how activist courts should be. How deferential should they be to political branches more generally? I don't think that's an open question anymore. I think originalists are more or less on the same page now. The activist won, the more restraint, deference-oriented originalist lost. And there's not a lot of ongoing debate either in the judiciary on that question or I think in academia on that question. I could be surprised, maybe there'll be a resurgence of interest in judicial restraint, but it seems like that's mostly, we've moved past that. But I think things are still very much open and need further discussion is one, questions of stare decisis that remains, I think, very unsettled in the originalist scholarship is clearly of deep interest to the courts. And I think it behooves originalist scholars to continue trying to think seriously about stare decisis and how it fits into a theory of originalism. And then secondly, and not so relevantly for courts, or internal debates among originalists, I think it's still worth thinking through questions of justification. Why should you be an originalist in the first place? And like I said, that's not a point that I think is central to what courts need to know. It's not particularly central, I think, to what originalists need to know for their own internal debates. But I think it is essential to what originalists need to be able to argue for external debates. So how do we persuade those who are not yet originalists that they ought to become originalists? How do you combat those who are offering other kinds of approaches, thinking about the Constitution, in order to persuade outside audiences that they ought to take our path rather than the opposite path. And that still will require, I think, thinking seriously and explaining justifications for this kind of constitutional approach rather than others. So let me leave it there.
Very good. Thank you very much. Hey, hi everyone. How are you today? I hope you're doing well. Michael, Rebecca, thank you so much for having me. Thank you so much for organizing this. To see a lot of friends, it's just wonderful. This is a wonderful event. Judge Oldham, I wish you could be here. I'm a technology guy. I would love to talk about history and technology and how to think about technological change from the standpoint of interpreting the Constitution. Maybe we'll get another chance, I hope. I'm going to talk mostly about the fact, Michael invited me here because I have a book coming out, available in fine bookstores near you, in January, February, called Memory and Authority, the Uses of History and Constitutional Interpretation. What about that? So I'm going to talk about some themes from the book, and they'll be pitched at a fairly high level, but I hope that as I talk, you can see their connection to some of the more specific debates we've been having over the course of this wonderful conference. So the first thing I want to ask is, well, why are lawyers interested in history? And the reason is authority. I mean, the book's titled Memory and Authority, so let's talk about authority and then let's talk about memory. Lawyers care about history because history gives them authority for what they want to do. And lawyers care about history because it allows them to undermine the authority of people on the other side of an argument. And so many debates about history are basically debates about forms of authority. But it's very important also to understand that lawyers never directly appeal to history. You may think that when lawyers have debates about history, they're really having debates about what actually happened. They're having debates about whose history is better. Oh, you got your history wrong. No, your history's incorrect. You didn't do that. That's not what's going on. When lawyers and judges make historical arguments, they're always channeling history through appeals to background topoi, methods of argument that are standard forms of argument in constitutional law. So for those of you who know Philip Bobbitt's work, know that Philip wrote a book about the modalities, the standard modalities. These are standard forms of justification that lawyers use, rules of thumb, that connect kinds of arguments to the authority of the Constitution. And so when lawyers argue about history, they are never simply making historical arguments. They are making arguments that are connected to one of the standard forms of legal justification. And Philip made a mistake because he called one of them historical. That's not correct. They're all historical. You can use history for all the different modalities of argument. But a lot of what lawyers are doing is they're appealing to, say, a textual modality, or a modality of purpose, or a modality of consequences, or a modality of structure. And they're reading history in light of that particular modality because that's the modality that connects their historical argument to authority. It's what gives it authority. So it's very important to understand that often when lawyers make historical arguments, they don't tell you what modality they're using. You have to infer it from the particular argument they're making, and often there can be confusions about exactly what kind of argument is being made here. Often lawyers trade on these confusions to give their arguments a bit more heft than they otherwise would have. Also, when lawyers use history, they are actually engaged in a very complicated dance of 4 different kinds of moves, which the first I'll call obedience. That is, they did it this way, we should do it that way. We should be obedient to the past. We should obey what the past is. You can obviously see that in standard forms of originalist argument. Because they said this, we should do that. Because they did it this way, we should do it that way. That's an argument from tradition. But lawyers don't just do that. Lawyers also engage in a kind of history, what I'll call critical. That is, a critical account is, because they did it this way, we shouldn't do it that way. Let us never again do what they did before. Right? And what undermines the authority of such and such is the fact that it arose from this thing that we reject. Earlier, Riva was making an argument tying Dobbs to the Southern Manifesto. That's a critical use of history that she was engaged in. And the important thing to understand is that lawyers just move from obedient to critical just like second nature. And often what we're trying to do is, you give me your sources and then I hit you with a critical response. You shouldn't use history that way. That's what we should not do anymore, right? There's another set of moves that lawyers are making, which I will call constructive and deconstructive. Constructive, the history tells us and the authority is clear and therefore we should either do it because they did it that way or we shouldn't do it because they did it that way. So in either case, you're making a claim about the constructive use of authority to construct authority. But what lawyers often do is something quite the opposite. They say, you know, the history isn't really clear here. You really can't make a clear conclusion about what we should do from the fact that the history was this way or that way. So for example, when you say the past is a foreign country, right? You're actually making an argument that, in fact, history doesn't offer you clear lessons about what you should do today. And so this form is not constructing authority, it's undermining the use of history for authority. I call it deconstructive. And a good lawyer, we have a very good lawyer right here next to me, just moves seamlessly from critical uses of history to obedient uses of history, from constructive uses of history to deconstructive uses of history. And they engage in this dance between these four different types, and they do it all the time, and everybody knows how to do it. They just aren't self-conscious about what they're doing. The next point I want to make is that often lawyers and judges talk about history as if it is a command. But I am here to tell you that history is a resource, not a command. And it basically, it never tells us what to do. Rather, we, channeling history through these various modalities of argument and these various four styles of historical argument, create for each other historical claims about how we should go forward into the present based upon our understanding of what the past means. And history is the resource by which we make these kinds of claims. And when I say that history is a resource, I don't mean simply as a rhetorical resource. I don't mean simply that history is just a bunch of arguments that I make and you make, and we all go and have a beer together and ha ha ha. No, history is a resource because history is what we are made of. History is the source of our meaning. It's the source of who we are and how we came to be, and how bad things happened, and how good things happened, and what should follow from the fact that bad things happened and good things happened. We are made of history, and that is why history is this unlimited resource for legal argument. Now, the next thing I want to say, I said a lot about authority and how lawyers use history for authority. Now let me talk about memory. So it's memory and authority. What is memory? Reva has already spoken about memory. And Reva and I, by the way, have had an ongoing conversation about constitutional memory for a long time. And so what I was going to say is going to connect to what she was saying in the previous panel. When lawyers use history and judges use history, they're engaged in a kind of memory. What do I mean by memory? Well, there's what happened in the past, and there's what we remember about what happened in the past. And what we remember about what happens in the past is memory. And in particular, sociologists talk about collective memory or cultural memory. And collective and cultural memory are the memory that a particular group, a profession, a nation, a people, a religion, remembers about its past, both what it achieved and what it didn't achieve, the good things that happened to it and the bad things that happened to it, the wrongs that have to be righted, its achievements, what it should be proud of. This is memory. And cultural memory refers to collective memory that nobody lived through, but we tell stories about. And so much of what constitutional argument is about is this construction of cultural memory, of collective memory. And the important thing to understand about memory, as opposed to simply an account of facts, is that memory is always normative and didactic and interpretive, rather than simply a description of what's going on. Memory has lessons, right? It has heroes, it has villains. It has who did what and who owes what to whom. And memory is always accompanied by erasure. So what we remember is also accompanied by what we forget, or what we erase off the scene. And that's important, because memory is a source of normative claims about duty and obligation and right and wrong. But what is erased can have no claim on us, because we don't remember that it happened. So if something goes down the memory hole and is erased, then its normative power to shape what we have to do now, what we owe to each other now, is also erased. And so that's why memory is what lawyers are engaged in. They say it's history, but they're actually engaged in memory. The next point is simple. Lawyers are memory entrepreneurs. What do I mean by that? Lawyers are spending an enormous amount of time getting people to remember things some ways and not other ways. And so they are simultaneously engaged in the creation of a certain memory of the past and in a certain form of erasure of the past. Because of course, for them, history is always a normative project. It's always a prescriptive project. The standard forms of argument that lawyers use when they engage in historical argument are exercises in memory and erasure. This would be a complete different presentation, so let me just give you a few examples. Let's take tradition as just one example, because we've spoken about it during this conference. A tradition is something that we in the present tell. It's a story we in the present tell about how things are and how they came to be, and how people organize themselves and arrange themselves. And it is normative and didactic, too, because tradition has hold over us. It's a claim about where we are and what we should do. But even if we break from it, even if we say we shouldn't obey this tradition anymore, it still has a hold on us because it's ours, you see. But to construct a tradition always involves erasure. For example, we might look to only what a dominant group in society practiced, and we pay no attention to what those who had no voice did. We may not pay any attention to exceptions. We may not pay any attention to geographic diversity in practices. We may pay no attention to slight changes between decades or even hundreds of years. Rather, we tell a story about a tradition which seems to be unbroken from the past into the present. And that is an act of erasure as much as an act of construction of memory. Tradition is always read from the present backwards, and it's usually based on the erasure of dissenting groups or subaltern groups or some other forgetting of a certain form of geographical or temporal diversity. That brings us to the problem for lawyers. And in Bruin, I'm surprised nobody mentioned this before, but there's this moment in Bruin where Justice Thomas basically says the quiet part out loud. Justice Breyer, dissenting, says, how can you do this Second Amendment analysis? You're not a PhD in history. You don't know any history. You're not an expert in these fields. How in the world are we ever going to do it? And Justice Thomas says, without any sense of shame, that's his superpower, we here in the courts abide by the principle of party presentation. What does he mean by that? He says, we don't do our own research. We don't have to do our own research. Instead, we rely on the presentations of history that are presented by the parties before the court and by the amici before the court. That is to say, we outsource to them memory. We tell them, produce the memory, and then we will decide for ourselves what account of memory we think is the most persuasive. And that's going to create a problem, because if I were to tell you that the people I'm outsourcing memory to are advocates, adversarial advocates representing clients or representing particular interest groups, you might kind of look askance at your sources of memory. You might think, well, gee, this is not a great way to run a railroad. But even more, because judges and justices don't have a lot of historical training, they're not PhDs in history. And for that reason, they have to decide who to trust. That is, they have to decide which stories, which amici, which clients, which person's version of history they're going to trust as having the correct meaning of history. And therefore, which history occurs, is accepted in the opinion, like Bruin, will depend on which the justices trust. And who they trust is not a matter of historical accuracy. It's a matter of sociological connection, sometimes ideological connection, and sometimes other forms of connection as well. The last thing I want to say is you might think, from what I have just said about Justice Thomas and Bruin and tradition and memory and erasure, that I don't believe that we should be making arguments from tradition or originalist arguments. Quite the contrary. I have a whole chapter in my book called Originalist Argument for Everyone. And in this chapter, I make the argument for why people on the left like me, I'm a liberal originalist, you should understand, but many of my liberal friends are not originalists. They don't like originalism. They don't like arguments from tradition either. But I'm talking to my friends on the left, and I'm saying you should be making originalist arguments. You should be making arguments from tradition. And I give a whole bunch of reasons, but the one I want to close with is very simple. If you refuse to engage in arguments about the meaning of the past, about the memory of the past, then you will live under somebody else's memory. Because memory, which is what lawyers do with history, has the power to rule you. It rules you not because it is a command, but because we in the present use memory as a way of articulating what our values are in the present. Thank you.
So I want to pick up with the comparison that Riva was making, where she was talking about how Dobbs tries to wrap itself in brown. And I think this is something that huge numbers of different kinds of Supreme Court cases over the last 40 years have done, which is, I called it in a paper I wrote several years ago, "What can Brown do for you?" And the thing that's most interesting here to me is that Dobbs wraps itself in Brown, but of course Brown's claim about what methodology should be used for the Equal Protection Clause is the absolute antithesis of what the court says in Dobbs, which is in Brown, the court says, we can't turn back the clock to 1896. We're not going to look at stare decisis. It says we can't turn it back to 1868 because things have changed and public education plays a different role here. And I just want to say a couple of words about what kinds of history we use and what parts of history we kind of fail to grapple with, because it seems to me that much of this is tied to race and much of it is tied to the failure of Reconstruction to actually realize the promises of the 13th, 14th, and 15th Amendments. And I'll mention two cases that the court has on its docket for this term that I think involve these issues. And I should say I'm speaking here completely in my personal capacity because some of this is stuff I worked on at the Department of Justice when I was there before I came back to Stanford. So the first of these cases is the North Carolina affirmative action case, the Students for Fair Employment, Students for Fair Admissions against North Carolina, which is a challenge to the use of race-conscious admissions policies in public institutions. Most people have focused, I think, on the Harvard case, but that case is about Title VI, not about the Constitution. And I think it's pretty clear from the oral argument the Supreme Court is going to say something like the North Carolina plan violates the Equal Protection Clause. And I'll make two predictions about this. The first is the court is either going to ignore entirely or misrepresent the original public meaning of the 14th Amendment and the understanding about whether race-conscious action was permissible under the Constitution. And the second is that the court will largely ignore how North Carolina's history failed to include people of color for 75 years, which explains in part why affirmative action today is necessary to ensure that they have a racially diverse student body in a very racially diverse state. The second case that the court has on its docket that I just want to mention is a case called Merrill against Milligan, which is about how Alabama redrew its congressional districts after the last decennial census. And this is a case about whether Alabama should have drawn two districts that were majority black or was entitled to draw only one district that was majority black, a district that is the successor district to a district the state was forced to draw by the Voting Rights Act in the 1980s. And the argument on the other side about why Alabama shouldn't have to draw this second district that would be majority black is that Alabama is entitled to rely on its traditional districting principles unless and until you show that they have purposefully discriminated against black voters. But I think it's fair to say that the traditional Alabama districting principle was to ensure that black voters never were able to elect a candidate of their choice to Congress. And we just don't confront these parts of history at all. Instead, we focus very much on some other parts of history. So I'll say one last thing about this, which is about a case that we litigated that the Supreme Court decided in 2020, a case called Ramos against Louisiana. This was a case about whether the Sixth Amendment to the Constitution, as incorporated some one way or another against the states, requires that states use unanimous juries. And there are two states in America that didn't use unanimous juries. One of them was Louisiana, where our client, Mr. Ramos, lived, and the other was Oregon. And the Supreme Court ultimately, in Ramos, overruled its earlier decision in Apodaca against Oregon, which is a case that it's not even worth trying to explain the divisions in that case. But the court overturned that and held that the Sixth Amendment, as incorporated some one way or another against the states through the 14th Amendment, requires unanimous juries. And Justice Gorsuch's opinion for the court mentions the racist history of both of these non-unanimous jury provisions, that the Louisiana provision was part of the Constitutional Convention of 1898, whose avowed purpose was, I'm just going to quote here, to establish the supremacy of the white race. And they knew that they couldn't simply exclude all black people from juries, so they came up with the idea, we'll make juries will allow juries to convict by a 10-2 vote, because that means even if a couple of black people get onto the jury, we can still convict people without worrying about what black jurors think. The Oregon rule was adopted in the 1930s after the rise of the Ku Klux Klan and in Oregon, and it was adopted after a case where they couldn't get a conviction from a unanimous jury that involved a Jewish litigant. Nobody contested any of this, and yet, having said, well, you know, these things had a kind of racist origins, the court didn't then say, and therefore they violate the 14th Amendment. It then went on to analyze juries back to the time of Blackstone, talked about 14th century England, took a tour through things that James Madison thought about, talked about state constitutions at the time of the framing, talked about various stuff that happened in post-adoption treatises from the 1830s and 1840s. We spent a lot of time, and this is what Jack was alluding to, we spent a lot of time in our briefing putting all of this stuff out there for the court. But we also put out there the claim that this was racially discriminatory. And one of the things that was interesting to me is that in the dissent by Justice Alito, what Justice Alito said was, you know, he condemned the majority for even mentioning the racist origins of these provisions. And he said, too much public discourse today is sullied by ad hominem rhetoric against ad dead hominy, I would say. And he says, you know, the majority regrettably succumbs to this trend. At the start of its opinion, the majority asks, why do Oregon and Louisiana allow non-unanimous convictions? And the answer it suggests, racism, white supremacy, the Ku Klux Klan. And then it goes on to say, if Louisiana and Oregon originally adopted their laws allowing non-unanimous verdicts for these reasons, that is deplorable. But what does it have to do with the broad constitutional question before us? The answer is nothing. So the kinds of history we use and the kinds of history we choose not to use, which parts of our history we choose to talk about and which parts of our history we choose not to talk about, is, I think, really important in understanding how you use history if you're trying to litigate at the court, and what kinds of history the court is interested in hearing about, and what kinds of history it just wants to say are the past and no longer with us. As Jack knows, I can now ask the question that people often ask after giving their little spiel like that, which is, so what do you think of what I thought? But instead, or there's also the am I right or what version of that question. But instead what I'll do is invite the panelists each to respond to each other if they'd like, and then open it up. In opening it up, I'm going to take the moderator's privilege of saying I'd love to have some of the many students who are here and have been listening to stuff over the last 2 days come and ask some of the questions. And if they don't, I know a lot of you because you're in my class, and I'll just be cold calling, so.
That is threatening.
Yeah.
I was just going to say, all right, I'm going to say what I thought about what you said. So doesn't Justice Alito, Reba and I have talked about this, doesn't Justice Alito have another case in which... Oh, I'm sorry. But it's always better sotto voce, you see. Isn't there another case involving the religion clauses? Yeah, Espinoza versus Montana, in which it's very, very important to Justice Alito that a lot of these laws restricting money going to private schools were based on anti-Catholic bias?
Yes, that is true.
Okay, I have nothing more to say.
I'm happy to get on to questions.
Judge Oldham?
I'm happy to offer just a couple of things. One, I was grateful to Professor Whittington on the sort of methodological point that he made. I mean, obviously, I agree with a lot of what he said, but I think one thing I am grateful to hear is some consensus on it, on at least the importance of the methodological questions. One thing to Professor Vulcan that, and I share your regret. I wish I was there with you in person. I would love to have an opportunity to chat formally and informally. But one of the points that I heard you say was, one of the importance of focusing on these historical questions is that courts are often at the mercy of the parties that bring the arguments before them, and so courts are going to have to decide which party's memory to trust. And I think it's an interesting point. I confess I hadn't thought about it before. But one of the most interesting historical issues that I have been sort of focused on in originalism debates is the difference between purportedly originalist decision-making, where both the majority and the dissent agree on the relevant memory. That is, they agree on the relevant sources. So, for example, one of the ones I alluded to earlier in opening is the case of Torres versus Madrid, where the majority opinion and the dissenting opinion both agree that the most relevant historical source, historical memory, to use the vocabulary of your opening, is this Countess of Rutland's case, and has something to do with a sergeant and mace and attempting to touch somebody and arresting them, et cetera. And so there's no real dispute about like what is the relevant memory. Everyone seems to agree that we need to read this case, we need to think about this case. And the court obviously comes out to very different conclusions about it. The other one that I suppose at this point, old hat, especially in a post-Bruin world, but back in the day when folks would talk about Heller as the example of how we're all originalists now, it's always been striking to me that it's not just that everyone agrees that we should be originalists, as Justice Kagan had pointed out. It's that they're looking at the exact same muster logs. They're looking at the exact same records of who can use what musket in what circumstance under who checked it in and checked it out, and that sort of thing. And obviously Justice Stevens and Justice Scalia come to wildly different conclusions even when they agree on the relevant memory. So anyway, I'm grateful for the talk. I thought it was quite interesting, and I look forward to the book.
Great. So Michael, am I just supposed to start cold calling on them, or do you want to come to the microphone? Yeah, Luke, the microphone's over here. Oh, great. Carolyn, you're coming too? Excellent.
Thank you, everyone. Thank you, Professor McConnell, for organizing this. So it seems to me, as many people have cited, that the court has been more and more citing to history and tradition as an authority. If you look at the unenumerated rights cases, it seems that the specific history and tradition the court is looking to is a history of state legislation, state laws. That seems to have a democratic appeal in terms of, and it has an appeal in that it's something that, a tangible appeal that you can point to. So I'm wondering to include more, to have more like inclusive history, what sorts of authorities would be, should the court be looking at? Thanks. I'll sit down.
All right, you want me to start?
Sure.
All right, so I just want to point out that appealing to states, right, counting states, for example, has, as you said, some democratic advantages to it. But it also has certain problems. A lot will depend on who's in control of the state governments at particular points in history. So if, for example, women can't vote in the states, or if state legislators basically want to pursue a particular definition of birth or rights, which is contrary to what is the generally public understood conception of, say, quickening, which is what Reva's article talks about, then you can't necessarily rely on the state legislatures as a reliable source for what the people want, right? So in other words, it's a proxy. What states do and how they create law is a proxy for understanding what we, the people, think is our fundamental rights. But it's not a perfect proxy. And it's not a perfect proxy precisely because, in fact, what you're looking at is who had control of the lawmaking apparatus at a particular point in time. So one of the ways in which you counteract that or add to it, or have, Riva says it's a democratizing memory, I would say it's an expansion of constitutional memory, is a point that Kurt Lash mentioned. He said, well, let's look at the conventions of free black citizens before the Civil War, as Kate Mather has suggested. Let's look at the people in the suffrage movement who could not vote, and the conventions of free black citizens could not vote. These are people who are part of the we the people, but they aren't mentioned as contributing to the constitutional conversation. Greg Blosky's written an article about the constitutional claims that were made by Native American tribes. They were making constitutional arguments, but in fact, they weren't basically dominant. They were in control of the lawmaking apparatus. But nevertheless, the people who made these arguments might have something interesting to say to us today. And I want to emphasize this point, that when we engage in the construction of the Constitution today, we are not necessarily interested in who had the majority view. Otherwise, no one would pay any attention to Frederick Douglass, right? Frederick Douglass is not the majority view when he's making these speeches. But today, we honor him as an important contributor to constitutional discourse. So what we're actually doing in the past is we're looking at voices and saying, you know, on the whole, these people had it right. They actually were wiser than many of the people who were in the majority. And it's their account of the Constitution that we should actually pay attention to. These are the voices. They should be makers of constitutional meaning. And it's very important to understand that when we look to the past for the construction of a tradition, we are always being selective. We are always saying who should be a maker of constitutional meaning for us today. And that is not the same thing as who had control of a majority in the past.
Yeah, so I guess I'd build on that and also depart from it to some degree. I think it does point to an important question about why you're looking at the past and what are you attempting to do with it. So if what you're looking for is what is the authoritative meaning of the constitutional text in question as written and ratified, it matters who's in control of relevant institutions, precisely because they are the lawmaking authority that can both create text and authoritatively tell you what the text means. And so I think for certain kinds of appeals to history, you have to be constrained by who actually is running the show at a particular time. For other purposes that we might want to appeal to history, that's not necessarily the case, I think. So as I think Kurt Lash was suggesting, in part, if you want to adequately understand the meaning and sources of provisions of the 14th Amendment, for example, trying to think through an extended debate that's occurring leading up to the 14th Amendment across several decades that includes a lot of marginal voices as part of that process, you're going to misunderstand what the Republicans were trying to do, how they understood themselves, and the kind of text they're adopting, if you're not paying attention to that prior debate that sort of led us to the place of the 14th Amendment. And so in that context, I think some of that earlier, including history from fairly marginal figures, can be quite significant. I think in other cases, though, what you're doing, and I don't know if Jack meant this in this context, but he said constructing a tradition, right? And so for me, construction has a particular importance that overlaps a lot with what Jack tends to think about with construction as well. But I think there are going to be spaces in which you want to construct meaning that is not part of the original meaning of the text per se, is not authoritative in the same sense. But it's precisely then when you're trying to make a persuasive appeal to people about here's a constructed memory, here's a constructed tradition that we think ought to guide us politically going forward. Precisely when you're trying to construct that, you're trying to recover certain memories while trying to erase others, then in fact you're going to be making some choices and may well be appealing back to say, Frederick Douglass, much more useful to us than thinking about some of the guys on the back end of the 14th Amendment who are justifying the creation of Jim Crow, for example. That's a memory we'd rather suppress and erase, whereas Frederick Douglass becomes a memory we want to build on going forward. And the question is, I think, who is constructing that particular tradition as institutionally speaking, who's constructing it and for what kinds of purposes. And I think if we're not talking about courts and we're not talking about ConLaw per se, there's a lot of space for appealing to those kinds of sources. I'd be, I think, more modest about what it is that's be appropriate for courts to do.
Judge Oldham, did you want to add anything?
No, thank you.
Okay. Luke?
Thanks to all the panelists, I appreciate it. This question is for Professor Whittington. You mentioned in your remarks that owing to kind of the appellate structure of our system, that hierarchy, that one of the Supreme Court's main roles might be providing sufficient guidance to inferior courts. So one way in which they can do that is doing the engaging in the kind of hard, long-term historical analysis, thus relieving the inferior courts of that responsibility. But you also seem to indicate that Another way they could do that is just issuing a lot more opinions, so they both have to go wider and deeper. If that's the case, what additional resources might the Supreme Court need? Clerk seems like, an easy kind of button, but it seems like what you're suggesting might be instead something like more folks with historical training, PhDs in history, that may not be a clerk, but might be, of great assistance to judges. Thank you.
Yeah, that's an interesting question, because you're right. I mean, to the extent the court would be taking more cases and more of them would require that kind of decision-making, then you may well think that more resources is not entirely acceptable to sort of say, well, we'll outsource that to the parties and we're good. You might want more resources on the court itself to address that. I don't know, though, if it's intrinsically the case that if the court had more cases on its docket, it would necessarily have to have a deeper dive in this regard. So to pick up on a point, I think, and I don't know if Will would endorse this, but to pick on a point that Will was bringing up in his talk at lunchtime, right? If part of what we think even an originalist-minded court ought to be doing is engaging in a certain kind of common law reasoning and thinking through analogies and how they work. It would be very helpful if the court actually, if the Supreme Court was actually working through more cases, so we had more data points to draw on to figure, okay, well, now I understand the analogy, now I understand the underlying principles, now the lower courts have more direction to go with moving forward. And that doesn't necessarily require that each one of those then requires extensive independent historical investigation in order to lay it out, but instead it requires the court to articulate more clearly, this is what we think the principles are that we sort of drew out of these earlier cases, and now let me clarify how you'd go about the process of drawing out the analogies and working through multiple cases in that form. And so I think it depends a little bit on what that docket looks like, but I don't necessarily think that if you expand the size of the docket, you're necessarily going to have to intensify the resources the court would need under those circumstances.
Are there any other students that wanted to ask questions? I want to make sure that they get a chance.
I wanted to ask a bit more about how we deal with gaps in history, and also like which history you use. Like, for example, the dissent in Dobbs raises a real concern about how the 14th Amendment just didn't deal with, women's rights enough. And so, like, does originalism have an answer for that? And and again, just like back to how, which history do you use, et cetera? Like, what's the methodology? Because I know that, with Frederick Douglass, for example, you're sort of sometimes picking up the Minority Report. So can you talk a little bit more about that?
So I think, from my perspective, there's I guess two things to say about this. I mean, one is I think there are going to be some gaps in the historical knowledge. I think it's just a real feature of originalism and historical argumentation that some things are not going to be as clear as you would like. And courts ought to be cognizant of that fact, that the evidence might run out on you before you have all the satisfying answers or are confident enough in the answers as you might like. And so I think especially for those of us who find originalism appealing, there's also a real need to grapple with the fact that the history will not always be as comprehensive and as clear as you would like, and that may create gaps in knowledge and meaning. I think but the other element of what you just suggested as well, sort of thinking about, for example, to what degree is the 14th Amendment relating to women and relevant to those considerations? There, I think it's less a question of gaps than a question of how we ought to be thinking about the meaning of the constitutional text. And one of my concerns about this kind of appeal to tradition is it's very similar to another kind of move that some originalists would make, and I think it would be a mistake, which is to focus closely on applications of doctrine or of the constitutional rule per se, and then really think, well, what the Constitution embodies is a set of applications the legislatures, for example, were actually engaged in, or the constitutional drafters were anticipating and talking about in themselves. I think the core thing that originalists ought to be doing in trying to interpret the constitutional text is try to think about what's the rule that got embodied in that constitutional text. And then once you know the rule, then the judge's responsibility is to try to think through, okay, what's the applications of that rule that we ought to be thinking through in a principled fashion? Now, we may still find that some of the rules that are actually embedded in that constitutional text are unsatisfactory, right? In part because people were left out in the process of drafting and creating that rule in the first place. And that may lead you to think, oh, what we really need is an equal rights amendment to supplement the 14th Amendment because there is stuff the 14th Amendment just didn't do. But I think but fundamentally, I think the concern is that if we don't push originalist judges to go down the path of thinking too much about concrete applications, it solves some of the concern that you're worried about.
It's a great question. It ties into a long-standing debate within originalism. So let me see if I can state the debate very simply. So I distinguish between people who have a relatively thick account of original meaning and people who have a relatively thin account. And despite how I look, I have a thin account of original meaning. Very thin.
Very thin.
I wish my body could be as thin as my account of original meaning. But people who have a thick account of original meaning basically are interested pretty much in how lawyers at the time would have characterized the relevant principles, how would they have thought about the legal concepts, sometimes how they would have applied solved a particular problem. And that's a thickened account because it sort of delimits how you would apply it in practice today. It doesn't completely delimit it, believe me. Whereas a thin account basically says, okay, well, what was the meaning of the text at the time? And how we apply the text is going to be very much determinate on our changed circumstances and the world we're in now as opposed to the world then. So I tend to be of the view that the best version of originalism has a relatively thin account of original meaning and a broad zone of constitutional construction, which is a term that Keith coined back in 2000. Now, from the standpoint of history, I want to suggest that there's a real advantage to having a thin account of original meaning and a broad account of the zone of construction. And here's the reason. In construction, you're doing something very different than you're doing when you're asking original meaning. Original meaning is, well, that's the meaning, that's the law, we have to apply it today, just as we did then. But in construction, you're doing something different. You're asking, what is the best way in our time to realize the promise and purposes of some constitutional provision? So when we ask equal protection, for those of you who have a view different than mine on equal protection, I'm sorry. We ask, what is the best way to realize the Constitution's guarantee of equality in our time? And that's the question of construction, as opposed to the question of what do the words equal protection law mean, which is a question of interpretation. History, a thin account is much better because a zone of construction means that we don't have to treat history as a command. We treat it as a resource for understanding what our traditions mean today. And therefore, we can draw on groups that were shut out, that were minorities, that were not paid attention to, if we think that their account of the meaning of the Constitution in our time is a better, fairer, and more faithful account of the Constitution's deep meaning than even the people who were dominant in their day. So I actually tie my preference for a thin account of original meaning to my views about how we should expand constitutional memory.
So I know, Andy, you were coming to the mic, and while you come to the mic, let me ask a question based on that also ties into something in Larry Lessig's presentation in the last panel, which is, what do you do about Section 5 of the 14th Amendment with regard to all of that, which is, that does seem both in its text, and if you take Michael's argument about the redistricting case, in his article about the redistricting cases seriously, it also takes into account that they did not trust the Supreme Court to be the guarantor of liberty and due process and the like, and I think Mark Graber's new book is also doing that. What do you make of this sort of Section 5 argument?
Well, Keith, I just want to channel you here. So, and if I don't get it wrong, you can tell me.
Okay.
I understand Section 5 from this perspective of Larry's account of Congress constructing privileges and immunities as a classic example of what you meant by constitutional construction. Is that correct?
Yeah, I think that's fair enough. I mean, I think the question as well is sort of what's the scope of authority that's actually delegated to Congress under Section 5, right? Mm-hmm. And so the text itself suggests something more limited. I think the context and the larger sets of debates and understandings that were part of the drafting suggest something much more expansive. And so I have not dived deeply enough, I think, into the 14th Amendment history to have a really firm view about this. But my inclination is to think that the court over the last, 30 years, is far too judicial supremacist about Section 5, and we ought to be more departmentalist about it and think that there's a much broader capacity on the part of Congress to engage in creative constructions through Section
Yeah,
5.
and your account
I
of
mean, I think
construction.
when the last piece of the Warren Court to go with this court is going to be the announcement in Cooper against Aaron that we're the only people who get to decide what the Constitution means, you know. Everything else from the Warren Court will be, you know, like what's that line in Faulkner's
Right.
Nobel Prize speech about like the last human with the little pitiful voice hanging onto the rock in the sun as like nuclear winter comes on us screaming, I exist. It's going to be judicial supremacy.
I think there's going to be a lot. I think there's going to be a lot more from the Warren Court that's going to get preserved.
I
but-
just think it's the last to go.
Yeah,
I mean,
maybe,
I'm not saying
it may
that
actually be the
everything
free
else
speech
will go.
stuff, but yeah, no, that's right. The court has no interest in abandoning Cooper v. Aaron.
Yeah. Andy? And I think, Michael, you know, everything else on the schedule has like an end time, and ours doesn't have any end time, but I'm thinking maybe Andy is the last question.
Our
this-
space is infinite. So.
So this is for Jack. I was listening to your taxonomy of different invocations of the past, and I kept thinking, I've seen something like this before, and where have I seen this before? And then it popped into my head, of course, and I'm sure everyone else in the room was thinking the same thing, Nietzsche's use and abuse of history. So he's nodding. And so Nietzsche says, you know, there's 3 ways that you can use history. You can use it as, you know, the monumental, the heroic thing was done before, it can be done again. This encourages you to go out there and fight. There is the critical, you know, we look at the past and we say, you know, really bad stuff, and, you know, we gotta get rid of that stuff. That's the stuff that the sort of thing that I focused on. And then there's this third thing that you didn't talk about so much, which is antiquarian, that you look at the past and you say, you know, this is, you know, we've got good things from the past that are in danger, that we've really got to preserve and look at with reverence. And Nietzsche worries about this because he thinks that it's paralyzing, that you know, it tends to anchor us to the status quo and keeps us from doing things. In the present situation where we look at the court sort of invoking originalism and they're ready to just smash things that we actually, it took a while to build an apparatus that could give us, say, clean air or clean water, and you know, the court is ready to, you know, waving the banner of originalism, smash all of that stuff. I actually think that paralysis has its attractions.
Okay. I just want to say, this is not a conference on Nietzsche, but I want to say that in that he has different accounts of what he means by antiquarianism. One account is your account of what he means by antiquarianism, which is just stay put. But another account that he has of antiquarianism is basically history that has no use for the present at all. That is to say, just interested in history because it's the past, and I'm interested in the past. So you're reading him in a slightly different way than I would have read him. I just want to say that this idea in Nietzsche's essay gets transmuted in Van Wyck Brooks's essay on a usable past, which occurs about 1918 and is the origin of the term usable past. And all I will simply say, maybe it's a good place to end, is that lawyers are not interested in antiquarianism in the sense that I described it. Lawyers are always interested in a usable past because lawyers live in the present and they are trying to arrange the affairs of society. And so lawyers are much more interested in a past that is usable in the present than anything else, but that's just a feature of what it means to be a lawyer.
So I'm going to take this as an advertisement for next year's conference, which is going to be entitled History and What Text of Nietzsche. There's been a lot of thanks given, and I've been the recipient of a lot of that, so thank you for the thanks. But I don't deserve most of it, and I did want to recognize the people who have been so efficient that you may not have even noticed their presence, and most of all, Rebecca Talbot. Where are you, Rebecca? She is so excellent at what she does that she could even make me look good. So, and then, but also, Gisela Brown is here somewhere. and Maria O'Neill have, anyway, that triad has just done, I think, a superb job. And I also would like to thank all of the panelists who have just, who have been stunningly interesting and informative, and I think have been just a model of scholarly interchange. So let's have a round of applause for the panelists. And then I'm not going to talk for long, but the last person often offers some reflections from the day, and I just wonder if maybe here are a couple of, not a couple, I think it's 4 thoughts about advice to give to courts that are trying to engage in text in some kind of history, and I wonder if maybe this might even be some consensus. The word consensus doesn't have much application to most scholarly conferences, but let me try. And so the first thought is that when courts are engaged in this kind of interpretive enterprise, that they ought to be clear about what type of history they are actually doing and why, so that when you read the opinions, you get a sense of what's going on, why might this be relevant? And I'm not even, and especially, when is the evidence supposed to give us information about original meaning? When is the evidence some kind of liquidation, which is, I think, the idea that people in places of authority, often outside of the courts, have been reflecting upon constitutional questions over time, and sometimes come to conclusions which our nation may be, in some soft sense, bound to, and sometimes the history is designed to identify national norms, and occasionally there are some portions of the Constitution that seems to point to that, and so there's a reason for doing that. And then sometimes I think the history is really inspirational, that the purpose of it is to inspire us to some vision of the constitutional order that is relevant in some way to the case, but doesn't really answer the specific legal issues, but just makes us aware of the grandeur of the enterprise that we're engaged in. And I think it'd just be helpful if we could somehow tell. They don't always have to drop a footnote, this is point 1, this is 2, but in some way to have a little bit clearer sense of what they think they are doing and why. And the second point is, I think that the court needs to be much more careful about the use of practice. Now, I'm not sure we want to go as far as Michael Paulson and saying that we should always do what they say and not what they do. I think there's a lot to be said for what people do, but we do have to be very careful about it because oftentimes the failure of governmental institutions to exercise what might be their power isn't because of any thought that they don't have that power, but simply there hasn't been an occasion to exercise it, or some other reason. And we shouldn't take silence about practice as being evidence, concrete evidence that the government lacks that power. I think we also need to be careful when looking at practices as evidence of original meaning. And this is